experience in drafting and prosecution of patent applications in India and foreign countries, including PCT, US, and European patent applications. His areas of expertise include chemical, pharmaceutical, polymer sciences, and biotechnological patent applications. Before taking up legal services, he has wide experience in R&D, quality control, and manufacturing departments of a leading automotive tire and tube manufacturing company. He is also qualified as an internal auditor and is involved in implementing ISO 9000 quality system. It's an honor to have you talk here, sir. Over to you.
Thank you, madam. Thank you, Dr. Sirinivasan, sir, for giving me an opportunity. Being want of time, let us go to the straight away to the topics. I'm just sharing my screen. Is it visible? No?
Yes, sir.
Yes, sir. Visible, you can go for that another mode that is. Yes, sir. Yes,
Yes,
sir. Yes.
Thank you, sir. So basically, my topic is on the opportunities and challenges with respect to the IPR ecosystem. So what is the Atma Nirbhar? Basically, it is kind of a self-reliance to promote or provide opportunities for Make in India products. And that because of that, you can cutting the dependence on the import, but focus on the quality of the product to forget a global market access and all. And it is part of it. You should encourage innovations like patents, designs, trademark, copyright, and should safeguard the rights of the creators and facilitate a transfer of technology. That's what the whole concept is here. As mentioned by the earlier speakers, patent is in a business, it is a kind of powerful tool where you can dictate the terms with your competitors. It provides certain advantages, technical advantages. You can generate money by way of licensing or cross-licensing, and you can provide to access to third-party technologies. And because of that, you are earning money, you can put it in your balance sheet and you can get a secure funding based on your IPR. So everything is possible. I don't want to go too much into that one. As mentioned by Mr. Thangabandian sir, that opportunities is that startups, educational institutions, SMEs have a reduction in fee so that to encourage more patent filings from that community. Then examination is faster in certain technologies. In fact, I am getting an examination report within a year or so from chemistry and biotechnological innovations. Of course, you have to file yearly publication request and other things. And as per your understanding, certain government institutions reimburse the financial assistance for patent filing and prosecution. And as mentioned by Patent Thangabandian sir, that IPO provided the facilitators for helping the innovators. And another thing is you can expedite the examination of the applications if you follow the certain categories so that you can get a yearly grant of the patent applications in India. Then additionally, there is a kind of a career opportunity for the scientists or engineers in the IPR field. You can be a patent agent or you can be a patent examiners or analyst, technology transfer professionals. So everything is possible because basically it is kind of a technology with legal, so that you'll get wherever there is a technical input is required, you can be part of it. So this is for the scientists and engineers. Now I'm talking about focus on the problems which we are facing it, especially while drafting patent applications. The awareness in academia and SME is very, very low, especially on the IPR. And even if you go by that, they want to file patent applications, there is a kind of hesitancy in that providing full disclosure. Because if you see, as per the law, unless you provide full disclosure of the patent information to the patent office, you will not get monopoly rights. For that, they say that they want to keep certain information secret and all. It is not proper while filing a patent application because you have to disclose that full information to the patent office. Otherwise, what happens? Third party can reverse engineer a product. You can file a patent and he can enforce against you. So therefore, but better thing is you should file a patent for any product which you intend to market it. Then these are all the problem which another problem is the innovators or the applicants or especially from academia, they publish that information in a journal. Then they later realize that I missed the bus. Can I file a patent application in India? It is not possible because before disclosing to anyone, you should first file a patent application. Then only you can publish it. Then there are certain restrictions with respect to the patentability because Indian law prohibits new use or second use of known substance. That is, you come across aspirin. If aspirin is known for certain disease conditions treating, now you cannot patent aspirin for another purpose. These are the restrictions because that is various reasons are there. Then related to any traditional knowledge, it is not patentable. Then there is a problem with respect to patenting of softwares in India. And another problem is that not all the patent office controllers have the uniform interpretation of that certain aspects. Everyone have their own way of interpretation. So that's why there is a kind of a mismatch between the patent offices, so that the applicant's rights is getting curtailed. And another problem which we are facing is the patent office is very strictly interpreting that certain classes and say that you provide me the appropriate examples, then only I can give you the claims. If they do not have much examples, I will not give broader claims. You should restrict your scope of the claim. That was another problem which we are facing it. Then another issue is related to any biological material. See, whenever, as per the law, whenever there is a IPR is generated from any of the biological resources available, then you are supposed to get a approval for filing a patent application, or at least you should get approval before grant of patent in India. Suppose assuming that you file an application with some biological resources, then you can very well file a patent application, but before the grant, you should get the National Biodiversity Authority's approval to get a patent. In fact, a patent office will issue a conditional grant saying that you provide me that NBA approval, then I will grant it. And here another problem which we are facing is, as a patentee, as a patent application, I will be claiming n number of biological materials in my specification, but I have used only few. That is what, as per the patent law provides, that these few examples are more than enough. But what NBA is interpreting is, whatever the biological materials you disclosed in your patent specification, you should get approval from me, otherwise I will not provide you. Now the problem is, inventor would have provided few examples using few BRs, but other BRs it is possible because of equivalency you can use it. But they don't have any data or where they procured it, or they not procured it. So they are forced to remove those information from the patent application. So thereby the claim scope is getting reduced. This is another problem because of that additional kind of a regulatory from the Biodiversity Authority. Then, as you know, there is no presumption of patent is grant in India. So any patent application is filed can be subject to any pre-grant opposition or post-grant opposition or revocation as per the law specified in the Patent Act. The purpose is to prevent any frivolous patent applications, or suppose mistakenly some patent would have been granted, or patent may be granted but there are prior arts available, so therefore the novelty or it is very obvious. Those access can be issued, then can be objected before patent office, and as per the procedure, patent office put a hearing, then accordingly they disperse the application. So therefore, if for example, if your competitor is doing a product which is already you have done it, so you can very well file a opposition saying that it is not a patentable subject matter, or it is already known in the public, so therefore it is wrongly patent is obtained. Like that, you can have a kind of a grounds you can use it. Then another issue which we are facing is, as per the section 39 of the Indian patent law, any patent application made by Indian residents, it has to be first filed in India. If you don't want to file it in India and you want to file it in abroad, you first obtain a foreign filing permission from the patent office. Sometimes what happens, a lot of people, without aware of these things, they are filing a patent application in India, outside India, then subsequently coming to India through some other route. Then the patent office issues an objection saying that you violated section 39, therefore your patent can be subject to revocation or invalidation, because the law provides it can be deemed to be abandoned in case of a pending application, or if it is granted, it can be revoked by the patent office. Also, in addition, there is a penal provision available where the person could be imprisonment up to 2 years, fine, or both are possible. So therefore, my request is, whenever you are filing a patent application abroad without filing in India, please see that you are getting a permission, or at least you file a patent application in India, then file abroad after 6 weeks. Then another thing is too much compliance requirements under the Indian patent law. That is, whenever you are filing a patent application abroad, periodically you are required to update the patent office what is happening in those countries. Otherwise, it could be a ground for opposition or revocation under the Patent Act. Then another is once your patent is filed and granted, you are required to file annual working statement. Whenever you are trying to commercialize your patent which is linked to a product, then you should provide a data whether it has been worked in India or not. If it is worked, how much the cost you earned it has to be provided to the patent office. Failure or providing false information, it may attract an imprisonment of 6 months. Then another problem is, earlier we have a IPAB, Intellectual Property Appellate Board, where any rejection from the controller can be appealed to the IPAB. That was somewhat easier. But with the recent abolition of the Tribunals Act and IPAB has been abolished, now the applicant is required to appeal only before the High Court of different relevant jurisdiction. So thereby the cost of appeal is there, then there is a time consumption, then procedural difference between each High Courts are there. So there is it is a kind of a challenge to the right holders. I want to highlight one particular case study where we handle one patent application related to jackfruit. As you know, jackfruit is very well known. It is being cultivated in Kerala. And as per the inventor, up to 80% of the fruits is getting ended up in waste in Kerala. So he come across a unique process. Thereby, he is able to manufacture flour from the jackfruit, and it is very well effective in controlling diabetics. That is what he said. That he published in the American Diabetics Journal, where it says the results indicate a decrease in the glycosylated hemoglobin, fasting food glucose, postprandial glucose following consumption of jackfruit 365, green jackfruit flour meal, suggesting the therapeutic potential of green jackfruit flour meal in improving glycemic control in type 2 diabetics. So this is in fact very unique. In fact, the application has been filed in USA and other countries. But there is something very, especially this is very unique, especially using jackfruit flour which is getting wasted in a useful manner, which is he was awarded with a National Startup Award in food processing. So this is unique. So that what my thinking is, you always try to patent or try to cover a product through a patent, then you can use it as indicated by my earlier speaker. It can be commercialized through a appropriate industry. That's all my part of that. I want to close down my speak very quickly. So any questions, I can take it forward.